The Enforcement Directorate's fresh FIR with the Economic Offences Wing of the Delhi Police in the National Herald case, Congress leader and leading lawyer Abhishek Manu Singhvi pointed out, was belated and an outcome of his arguments made before the trial judge that no predicate offence existed in the case. The FIR, registered on October 3rd by one ED officer, Shiv Kumar Gupta, accused Sonia and Rahul Gandhi, Suman Dubey, Sam Pitroda, a company called Young Indian, Dotex Merchandise Private Limited, Sunil Bhandari, and Associated Journals Limited, and unknown people under the Indian Penal Code sections 420, which means cheating, 406, which means criminal breach of trust, 403, which means dishonest misappropriation of property, and 120B, which is of criminal conspiracy. They were all lodged against the accused in the National Herald case. The FIR alleges that the government properties which were allotted to the National Herald, a daily newspaper, at subsidized rates for larger public purposes were usurped by the Gandhis and other Congress leaders for personal gains. And thus, this kind of hijacking of lands represent a serious form of criminal conspiracy and financial fraud. However, Manu Singhvi responded rather aggressively. He said the new FIR in the National Herald case is also an unintended and inadvertent tribute to my arguments before the trial judge, pointing out that no predicate offence existed. He later added rather sarcastically, I also said that if there is no predicate offence, there cannot be PMLA, by which he means the Prevention of Money Laundering Act offence. There can be no PMLA offence. Possibly to take care of that huge jurisdictional gap, the present new FIR with a minor change has been filed. He called the ED overzealous prosecutor and over clever prosecution. Please remember, this is criminal law, not supposed to be adversarial or malicious, Manu Singhvi said. All of this sounds a little confusing, right? Abhishek Manu Singhvi, while trashing the FIR against Gandhis as fraudulent, effectively meant that by filing a fresh FIR, the Central Investigation Agency was trying to retrofit a scheduled offence as per the law that previously didn't exist, and which made the ED's case weak in the courts. The new FIR is sort of a corrective measure then by the ED to be able to stand at the court without being reprimanded by the judges. Now, we all know that both Sonia and Rahul Gandhi have been summoned by the ED and the Income Tax Department for questioning a number of times. All such instances have blown up and have become hugely flashed political sore points between the BJP and the Congress. But how much do we know about the case itself, which the BJP claims is demonstrative of the Gandhi family's malpractices, but which the Congress has been rubbishing all throughout as bogus and vindictive? Is it a case of political vendetta, or the Gandhis have actually done something that can trouble them in the future? Here at this show, The Wire unpacks all these components of the National Herald case that has emerged at various points as one of the most hotly debated and politically contested episodes over the last decade. Now, let me take you to the beginning. The National Herald was founded in 1938 as a newspaper in Lucknow by eminent freedom fighters from the then United Provinces, which is now Uttar Pradesh. These leaders were Acharya Narendra Dev, Rafi Ahmed Kidwai, Purushottam Das Tandon, Kailash Nath Karju, and none other than Jawaharlal Nehru. The parent company of the National Herald was called the Associated Journals Limited, or what I will now begin to call the AJL. The AJL's stated policy was that any publication issued by the company shall generally be in accordance with the policies and principles of the Indian National Congress, which was the primary political force in uniting people against the British at the time. The National Herald was also founded to create an alternative media space back then to disseminate anti-colonial views of the people when a large number of news dailies were advancing the colonial point of view or were being censored by the British. In that sense, the National Herald was and still is ideologically beholden to the Congress party, very much like AJL's other publications like Qawmi Awaz and Navjeevan. However, as the AJL didn't view its publications as a commercial enterprise, the National Herald fell on hard times after independence. Although suffering huge loss through the 80s and 90s, the AJL had almost become financially unviable by the later half of the 1990s. The National Herald struggled to pay salaries to its journalists and staff. It was then when AJL approached its ideological fountainhead, the Congress party, for financial support, as no bank was willing to support a company with a negative net worth. The All India Congress Committee then provided by check nearly 100 small loans to AJL from 2002 to 2010. By 2011, the loans totaled rupees 90.21 crores, all of which the AJL claims to have spent on paying salaries, gratuity, provident fund dues, taxes, and other government dues. The printing of the National Herald had been temporarily suspended in 2008. At this time, the then treasurer of the Congress, Motilal Vora, after seeking legal and financial advice from experts, designed a plan to restructure AJL as part of its revival plan, as AJL was far from being in a position to repay its debts to the Congress. The financial restructuring plan was supposed to clean AJL's books and pay all the unpaid taxes accumulated over the years so that it could approach banks for fresh loans for its revival. The revival plan also included creating new assets in the land parcels that AJL owned to drive up its revenues and subsequently hire a competent editorial team to initiate National Herald's digital publication. Under the financial restructuring plan, a not-for-profit organization called Young Indian, the company that is at the center of the National Herald case, was established in November 2010 under Section 25 of the Companies Act 1956, which in 2002 was changed to Section 8 of the Companies Act. Sonia and Rahul Gandhi, Motilal Vora, Oscar Fernandez, along with Suman Dubey and Sam Pitroda and some other Congress leaders were joint shareholders of this new company called Young Indian. The Congress received rupees 50 lakhs from Young Indian and gave this newly established company the right to recover AJL's loans totaling rupees 90.21 crore. Subsequently, AJL offered Young Indian created only to revive AJL, a proposal to convert these loans into equity, a common practice in the corporate sector to clean a loss-making unit under the Insolvency and Bankruptcy Code. Multiple governments too have converted debts of many companies into equity through this kind of a process in the National Company Law Tribunal. The financial restructuring in which Young Indian became the majority stakeholder or shareholder of the AJL gave the dying newspaper company an opportunity to start with a clean slate and enabled it to raise loans from formal banking channels. By November 2016, all the three publications of the AJL, the National Herald, Qawmi Awaz and Navjeevan, were relaunched as digital media platforms. So what is the legal battle about it? Why so much fuss in what looks like a regular corporate restructuring of a company? Well, the fuss began when Hindutva supporting politician Dr. Subramaniam Swami in February 2013 filed a private criminal complaint with the Metropolitan Magistrate in New Delhi. Swami, who formally joined the BJP in the month of August the same year, alleged that the shareholders of Young Indian, meaning Sonia Gandhi, Rahul Gandhi, Motilal Vora, Sam Pitroda, Oscar Fernandez and Suman Dubey had diverted Congress funds to a private company which is Young Indian for the benefit, for personal gains of the Gandhi family. Although he didn't provide any evidence to back his allegations, he claimed that Gandhi family, by becoming shareholders in in AJL through Young Indian had usurped AJL's real estate assets, thus committing fraud, breach of trust, and cheating on the Congress party. The allegations almost made Swami look like a well-wisher of the Congress party which had been cheated, although he had been one of the most vocal opponents of Congress in all his public life. In any case, the Metropolitan Magistrate allowed this private complaint, Swami's private complaint, in the court and summoned the accused Gandhis and others. The trial court hearings began in 2016 and went on till early 2021. During the course of the hearing, Swami was questioned and cross-examined multiple times, but he could not back his allegations with evidence. In fact, he remained absent in most of the hearings. His lack of interest in the case showed when he himself moved to the Delhi High Court to pause his own case. It is when this case was losing its steam, the ED stepped in and used Swami's private complaint to begin its own investigation under the Prevention of Money Laundering Act, PMLA, which meant that it had to furnish, the ED had to furnish evidence of money laundering in the restructuring of AJL by the Gandhis. Interestingly, the then ED director, Rajan Katoch, objected to the view that a private complaint also could be the basis of an ED investigation, and said that an ECIR, which is Enforcement Case Information Report, which is equivalent of an FIR under the PMLA, should follow legal rules, something that the Supreme Court too had observed in various cases under PMLA. This was probably for the first time when the ED had begun its investigation on the basis of a private complaint and not an FIR. Katoch was immediately transferred, and the ED under a new leadership launched a formal investigation in June 2021. In subsequent years, Sonia and Rahul Gandhi, Congress President Mallikarjun Kharge, by the virtue of being the party's president, and other accused, were repeatedly called by the ED for prolonged questioning. All this while, the leaders kept saying that the AJL and Young Indian were separate entities and no transfer of funds happened between the two ever. The revival of AJL has only been possible because of its rental incomes, and that Young Indian was floated only to enable AJL's revival. Not a single rupee, the Congress said, has moved from AJL to Young Indian or any of its shareholders ever. The ED has still gone ahead to pursue a PMLA case, although it still has to provide any evidence of money laundering. Meanwhile, the ED has withheld crucial documents from the public. These documents include Swami's own private complaint, those that provide evidence of AJL and Young Indian foundational association, balance sheets of both these companies, statements of Sonia and Rahul Gandhi and other accused, and even Young India's incorporation as a Section 25 not-for-profit status company. However, we must also take a look at ED's allegation. What are those? Around 6 months ago, the ED filed a charge sheet in the case accusing the Gandhis and others of financial fraud and money laundering. Let us look at it point by point. The ED claims that Young Indian was a sham company to grab land parcels which were acquired by the AJL through government subsidies for public service and news dissemination. The ED then goes on to say that the land parcels are worth rupees 2,000 crore and that the Young Indian shareholders took hold of those real or usurped of those real estate properties acquired through subsidies through a transfer of merely rupees 50 lakh that Young Indian transferred to the Congress to get the rights to recover AJL's loans. However, the Congress claims that the ownership of properties in the question remains with the AJL, and that AJL are the true maliks of those real estate properties, and that not a penny from the rental incomes of AJL was transferred to Young India. Moreover, the Supreme Court too has settled this matter. In its judgment in the Vodafone case of 2012, it clearly says that shareholding doesn't imply ownership of a company or its assets, and that it is the company itself which owns the properties. The Congress also says that no money or property has ever been transferred from AJL to Young Indian or its directors or shareholders. No gains were ever made either by the Gandhis or any of the other accused persons. The case of cheating also doesn't stand in this view, as no shareholder of AJL or Congress leader has ever complained of any kind of cheating against Young India. Moreover, the Congress has repeatedly said that the ED's claim that the AJL properties are worth rupees 2,000 crores is hugely inflated or escalated and is being quoted only to mislead the public. The Income Tax Department, which is following a separate case in the matter, itself had claimed that AJL's real estate assets were worth rupees 392 crores only in 392 crores only in 2010 and 11. Even by inflationary standards, they do not match up to the ED's estimates of rupees 2,000 crores. But there are two other significant allegations against Young Indian. One, the ED claims that the Young Indian acquired a loan of rupees 1 crore through a shell company to give it to the Congress and get the rights of recovering the debts from AJL. But the Congress has aggressively denied it and has said that Young Indian took a loan of rupees 1 crore at 14% interest in 2010 by a check from a legitimate company called Dotex, which is a RPG group company registered as a non-banking financial company by the Reserve Bank of India. So there is no question, the Congress says, of any kind of illegitimate or illegal financial dealing. The Congress has made more significantly. It said that the ED has lied on paper that Dotex gave a loan to the shareholders of Young Indian before they incorporated the new company. The Congress alleged that the check by Dotex was dated December 24, 2010, after the incorporation of Young Indian, and not on 24th October 2010 as the ED claimed in its charge sheet. The ED still hasn't responded to this grave allegation. And finally, why is the new FIR against Young Indian important? After the ED filed its charge sheet in the matter under PMLA, several legal experts pointed out that PMLA required the ED to begin an investigation only on the basis of a scheduled offence, something that the ED director Rajan Katoch, remember, the one who was immediately transferred after pointing out this loophole in ED's case. He had also said the same thing. The ED until now was interpreting the lack of a predicate offence that should be registered as an FIR in the National Herald case as unimportant. It said that the ED began its investigation after Swami's private complaint showed an occurrence of a scheduled offence that was also acknowledged by a trial court. Thus, it wasn't necessary that a FIR should be filed. However, the ED must have realized now that its argument wouldn't stand in the courts, because as per senior lawyer Sarim Naved and also Abhishek Manu Singhvi, a scheduled offence is a prerequisite for any ED action. Section 5 of the PMLA clearly states that ED action must be based on a police FIR or a statutory complaint, and mere court's cognizance is insufficient. Sarim Naved told The Wire, the entire idea of PMLA is that it can kick in only after the crime has happened, some money has moved or laundered. There is no provision in the law that an investigation under PMLA can be started by an investigation agency without a registered predicate offence. In essence, what Naved was saying, that no investigative agency can retrofit a predicate offence after the charge sheet is filed. You need a FIR fast, and what Naved said, a retrofitted FIR can be struck down at the court and can even be the basis to quash the PMLA charges in the National Herald case. That is what Abhishek Manu Singhvi, who represented Young Indian at the court, argued. And that is why the ED, which is already struggling to provide evidence to prove its allegation of money laundering against Gandhis, has lodged a fresh FIR with the Delhi police, citing scheduled offences like criminal conspiracy and financial fraud to cover up its stark oversight in the matter. Thank you.